Hello, everyone. Welcome to the Domain Name Law Show. This is show number 178. We broadcast live on Spaces every Tuesday, 3 p.m. Pacific, 6 p.m. Eastern. All shows are recorded and available for replay. Today, my co-host, Jeff Neuman, David Michaels, and I welcome special guest, Ms. Karen Bernstein. Now, Ms. Bernstein is an intellectual property attorney and much more. This afternoon, we're going to talk about her vast professional background, her practice today a little bit, and we have a bunch of questions for her, mostly about domain name law. First, I want to say, Ms. Bernstein, thank you so much for joining us. How are you today?
I'm doing great. Thanks for having me on the show.
Thanks for making time to be here. My co-hosts can greet you when they ask their first question, but we're going to jump right in. If anybody wants to follow along, you certainly can. Go to dnlshow.com, click on outline, and we try to stick to that. That's our guide. But first, we're going to talk about, Karen, your career before law is what I'm, really want to spend a lot of time with, but we want to talk about law in this room. But I love it. Very interesting. I've done some research on you, but can you tell us a little bit about your career before law?
Well, I'm not going to take up the show, but I was just at the right place at the right time in my life. I was a teenager. I grew up in the Philadelphia area, and Philly was still a music town. And I was in high school, and I was really interested in advertising. And I wound up becoming assistant PR director at the ad agency between my senior year and my first year of college. And the PR director at the time and I became friends. And she introduced me to a woman named Karen Young. And Karen Young had a top 10 hit called Hot Shot. It was like a, gold record, which meant something back then. And she and I became friends. And I wound up going with her to Holland and to England on tour. And we co-wrote a song called Hot for You. And it was a disco dance song at the time. I guess you call it old school now. And so I became an ASCAP member. It wasn't a moneymaker. I went to San Francisco, and I lived in California for 12 years. And I was in the advertising business. I sold advertising for an Asian American magazines and newspapers, which was very niche. And part of the reason I like niche includes domain names. So it's not surprising I got into a really niche thing later on in life, but I stayed there, and then I ran my own media rep firm out of Southern California. And at the time, the economy was not doing very well, and things were not going well with my business, where checks were being bounced. And I said, "Oh my God, what am I going to do?" And I have a background in typing; I can type. So I became a legal secretary. And I did temp work to permanent work, and I finally wound up at a really big, small firm, boutique, very cool firm. And I went back to college because I dropped out the first time and decided I wanted to be an IP attorney. And it took me 10 years. And then I got to New York. Along the way, I won a legal writing contest in law school that was sponsored by the Grammys. So I felt like I'd come full circle. And then I went to law school, and I got a job in Manhattan, and I've been in Manhattan now for 23 years. So, and the domain name thing. So I worked for law firms for a couple of years. One was a big entertainment firm, but it wasn't a big firm, just very famous. And I left them to start my own practice. And what I do is running Google ads, and I would get phone calls. I wouldn't believe it. You get a lot of tire kickers and weirdos and stuff like that. You get some really interesting people. And one day I got a phone call from a guy named Mark Ostrovsky, who you might know in the industry, is known for selling business.com in 1998 for, I think it was like $6.8 million or 8.6, something like that, and was in the Guinness Book of World Records. And he introduced himself to me just like that. And he said, "I really like your ad on Google. I'm a domain name investor. And, a lot of people like you who are trademark lawyers think we're bad guys, we're cyber squatters." And yeah, I did think that, because coming out of law school, I was doing domain name disputes because I graduated in 2001, which was the start of it all. And he said to me, I have businesses that I build websites on. I invest in domain names and trade them, and we're not all cyber squatters. and that there's only male attorneys in the domain name business, and he thinks that I would make a great addition to the industry. But and he wanted me to go to Las Vegas and meet him at Targeted Traffic. This was 2008, and he said that if I show up, he'll introduce me to everybody. And I thought, I don't know who this guy is. I looked him up. I looked up Targeted Traffic. They seemed legitimate, and I got on a plane and flew to Las Vegas and met with Mark, and had met Howard New, the late Howard New, and Rick Schwartz, and all those people, all the people I've known for years. So that was really cool. And of course, I have had my own practice for going on 18 years, and it's an interesting industry. I really enjoy the people a lot.
Well, well, Karen, thank you for all of that. I mean, I didn't know that it really was not that long ago. I mean, 2008, for some of us that have been around, right? 2008, you go to traffic, and yes, I've heard of Mark. I'm sure probably Jeff probably knows him much better than me, but I was going to say I've heard of Mark. And to go to that event, and it does make me sad to have to say, like you said, late Howard New, because I sure miss Howard, is
Yeah,
to meet these folks. And that was one of my questions for you later about the importance of going to these events, because I just saw you at NamesCon, and some of us said you've been
yeah.
going now 15, 20 years, and it's like, hey, so we've been to you go to a lot of other events too, legal events, but these domain events, I guess I'll get to it now, really valuable. You still go to them. What is the value of seeing potential clients face to face? And are you still, like when you were at NamesCon this last time, what do you get out of it? What's your intent for being there?
Oh, that's a big question. So I'm going to break it up in parts. The first one about domain name conferences is I love a lot of the people, and most of the industry is very friendly. That's the thing that I like about domainers. They're very inclusive, and yeah, sure, people like go to dinner and stuff like that. But I think for newer people, it's there are people like me who can help guide them, and sometimes it turns into an attorney client relationship. Sometimes it doesn't. But I'm not giving them legal advice per se. I'm just meeting them and talking to them, and seeing them, and of course continually seeing the newer people at other conferences. Then as time goes by, sometimes you get business out of that too. But I get a lot more out of domain conferences because I like the subject matter. And of course, I'm involved with ICANN, and Jeff and I are both panelists. The National Arbitration Forum, well, it used to be called that. It's called the Forum now, which does UDRP disputes. I'm a newbie, and and also Jeff and I've been on two I guess working groups. We're presently on one right now having to do with what we call string similarity with domain name extensions. But I'm going off on a tangent. So that was the first answer,
Yeah.
and then the second question was what again? Remind me.
Yeah, Karen, listen, we're going to just let this flow because I want to get to Jeff and David. They have some questions, and I have tons of questions, really, just because and they touch on so many different subjects. Um, so, Jeff, I see you're off mute, and you were dying to say hi to Karen. So go ahead, and then we'll get back to when she first started doing some domain name law cases. But Jeff, take it.
Yeah. Hey, Karen, how's it going?
Hi, Jeff. I feel like we see each other every days.
Yeah, it's always great. In fact, Karen, interesting fact, Karen was my last meeting prior to the pandemic. I was in New York and we went out to lunch um, and I remember Karen saying, "Oh, by the way, the guy down the hall from me, I think it was, because Karen did some shared office space, or at least was at that time." And Karen said, "Yeah, the guy down the hall from her had COVID, and it's starting to get a little scary." And that was what, like March 9th or 10th or something, pretty
Yeah, it was
close
it
to.
was early March. Yeah, somewhere around there.
Yeah, but we've known each other for a long time, I think. And I was trying to remember, but I think when I first met you was probably when you were doing work for .me.
Yeah, maybe. I mean, I was my first ICANN meeting was Toronto, and I think that was 2012. So that's all I can tell you. I know that we used to see each other. We are both on the intellectual property constituency. It's hard to
Right.
say. It's known as the IPC. So I don't know. It's been a long time, at least 10 years.
Yeah. So maybe you can go into, how you got what you did with .me Montenegro, how you got that, and what kinds of things you were responsible for.
Great group of people. I met Natasha, who's no longer there, and Predrag, he's still the CEO of .me in San Francisco. And that was around 2008. They were just launching their CCTLD, and I was so new. I was still pretty new to the situation. They hosted a lunch, and I met them. And then I'd say maybe 6 months later, they reached out to me and they needed something done in the United States. And it just things kind of grew. They had their premium domain program for many years where companies had to apply to them and explain to them, what their business plan was and that they were applying for, a very premium .me domain. For example, ID.me was a deal that I did at that point. So they would come to me for the contract work, and also going to ICANN and working with their government. I've worked with the government of Montenegro, and there's a funny story with .bar involving a little town in Montenegro called Bar. It has a ferry that goes to Bari, which is in northern Italy, and that's a lot of their trade. But the .bar story. Let me take a sip of water. I'll tell you quickly. It's a great story.
Karen, because I know I want to hear this, but I wanted some of the people don't really understand the .me story. I didn't understand it, and that is Montenegro.
Oh, okay.
It basically wasn't
okay.
around, and then so tell us there because it's interesting and how they said we want .me, and I'm like, we're sure you do, but you had to. So take it from there.
I think that it's a good way of comparing .me is that it was like the forerunner to .ai. So nobody knew about the .ai extension when it finally came out. I guess it was 10 years ago. I don't remember. But what really was a marketing company that knows how to work really well, has great partnerships with registrars over the world, and they work primarily as a registry, but they also do all the marketing. And then they would hire outside ad agencies and stuff that I've helped with them over the years because they like to use U.S. companies. They're co-owned by GoDaddy. Also, I'm sorry, the back-end affiliates, which is now known as Identity Digital, I think. Am I correct? Is that right, Jeff?
Yep, that's right. Yep.
Yeah. So, but yeah, like doing contests. I worked writing their contest rules. Working with them in that in that respect, and of course seeing them at ICANN and working with their government. And like I said, it has been a very interesting relationship. They stopped doing their premium domain program years ago that we did it. They did a deal with Afternic, was premium, and they went in another direction. But I'm always here for them in the U.S. if they need me.
Yeah.
Yes, I think what getting at is ME is interesting because what it was, Montenegro was kind of an outgrowth of a couple CCTLDs that no longer existed, right? So you had Yugoslavia, which was .yu, and that country ceased to exist. And what came in its place was Montenegro. Well, at least we'll focus on that one. And they didn't have initially a CCTLD, but they had to get a code, what's called an ISO code, an International Standards Organization code, from the UN-based organization that hands out those codes. And I don't know how, but they ended up getting ME. MO was already taken, and so ME was the next logical choice. So they kind of lucked in to ask such a great, CCTLD extension. And then the operator, the government did do an RFP for the back end.
For what does this P stand for again?
Yeah.
Request for
Pro-
proposals, I
yeah.
guess. Yeah.
Right. And I was at New Star and we bid as well. But the successful bid came from a partnership that Ken was saying between Affiliates and GoDaddy um, to run the back end. And so they were, I don't, I don't know. I guess Identity Digital still does the back end. I'm not sure. I haven't followed it in a long time. But yeah, I mean that it's an unusual story for CCTLD because not too many CCTLDs are born or die for that matter. The only other, there's been just a handful of others.
I don't
But
know of any
yeah,
other. I'm sorry, Rob. I don't know of any other CCTLDs that are American backed. I mean, like the relationship with GoDaddy and Identity Digital, but unless you do,
Yeah.
I think that makes it unusual too.
yeah. I mean, it certainly does. I mean, well, I think they've been, whether it's Identity Digital or New Star, they've gotten many back end deals, but really, Affiliates GoDaddy were managing a lot of it at the time, more than just the back end. They were doing some of the marketing and they were assisting and all that stuff.
In the very
Um,
beginning, yes,
right, right.
yes.
Well,
And as far as back end, yes, totally. This day, um, but yeah, that's true.
well,
So, anything else about .me? Do we want to talk about something
well, yeah,
else?
yeah, we're gonna get on. Yeah, of course, I got so many good things. But that bar story, tell us about that, and then I wanted to ask you about .ai, what's happening now, and then David, we'll get into some legal questions about UDRPs and stuff. But tell us that bar story, please.
This is a story that is just ridiculously unbelievable, but it's true. So there's this little town, like I mentioned, in Montenegro called Bar. And at the time that the new GTLD applications were happening, which was, 2000, what was it, Jeff? 2012,
Yep,
right?
that's right. Yep.
And there were two applicants for .bar. They wanted to have a TLD that was, a bar, like you drink. It was open extension that anyone could register a domain name, and they were applying. One of them was really to this, and they found out. Oh, not. I'm sorry. Let me back up. Under the rules in the applicant guidebook that you have to follow when you file an application, says that you can't register a domain name. I mean, among other things, you can't register a domain name that it matches the country code under a list with the United Nations. And so, like, .us is the country code for the United States, and .ca is the country code for Canada. .bar, as in bar, right, was not necessarily on the big list, but there's a subsidiary list of cities, and Bar's on that list. And so, essentially, one of the applicants went to the government of Montenegro to try and get them to agree to give them permission to use bar as a TLD, because that was the only way you can get an extension, is to get requests from the governing authorities. And they really didn't know what to do with it. And I guess it kind of got kicked around for months. And then finally, the government contacted the .me, and .me then contacted me and said, "We need your help." And so I worked with the mayor of the town to put out an RFP for the two applicants for .bar. And so one of them really stood out to me in a number of ways. One was that they're from Mexico City. They're still a TLD. And they also have .rest. Lovely people. They go into it. Guy got married and went on his honeymoon to Europe, and they went to Montenegro for several days, and they went to Bar. They went to the town, and being from Mexico, lo and behold, they were having lunch. This is the story they told me, at some diner in the little town. And when they said they were from Mexico, because they don't look like they're from the former Yugoslavia, Serbia area, and they said, we're from Mexico. And she said, that's interesting because there is an elementary school down the road that's called the Mexico School. And so part of their proposal was to donate money to the school every year for 10 years. And also their submission, just, I thought really that was the best recommendation that the mayor should go with, and they agreed. And then there was this where I flew down with the people from Mexico City. I got to meet them. And Central Nick was doing their back end. At the time, it was Central Nick. And so people from there also, we got on a plane. We flew from London, Montenegro, and we went to the school, and they presented a big check, and the parents were there, and the kids did Mexican dancing, and it was just a lovely experience.
Yeah.
So that's my Montenegro story.
Well, the mayor of Bar, I was thinking when you go to town and you're like, yeah, I'm having lunch with the mayor down at the little bakery right here. Well, Karen, I had a note from earlier that when you IP lawyer, I said, yeah, I wanted to be an IP lawyer too, but I didn't make it through to the end. So you made it through to the end. Before I get to the IP lawyer questions, you mentioned about, the .me. Okay, CCTLD, .ai is really hot right now. What do you know about, if you're representing a big company and they're like, we're going to build our company on this extension, what would you tell them when it's a CCTLD that's operated all in different fashions? Nothing against .ai. I know a little bit about how that's managed and so on. I don't know if it's any better or worse than, well, it doesn't seem as solid as VeriSign to me, but the point is, what do you know about the .ai, and what do you recommend if a client or somebody wants to build a company on a CCTLD?
Well, first of all, yes, a lot of what you're saying is true. In terms of the factor of a country being taken over, or some kind of riots, natural disasters, things like that could, unrest could certainly sway someone. I could sway a client that way, but the reality is that I have had clients in the AI industry who use .ai, but they also have many other extensions. So that's what you do. You diversify your extensions, and they all lead to the same website.
Yeah.
That's, if they can't get the .com, that could be a problem, and that has happened for some high-end AI companies I've worked with.
Yeah.
And either whoever owns it is like, we're not selling, or it's too much money for them at the time. It all depends on that. But, a lot of people have built websites on .tv. Gosh, right? If you look at television or streaming devices that use extensions, they also have other domain names they work off of. Yeah. So, if you're at that level of success, or even if you're not, you can afford to buy a domain name unless it's a name that everyone and their mother uses.
Yeah.
In which case, I would recommend you use it, because that's not a very strong trademark.
Yeah.
If everyone uses the same name.
Well, interesting about that, you bringing up TV, and we'll get onto some legal questions, is the .tv, one, I would say, defending all these CCTLDs, is, hey, listen, if you look at the history, everything's been fine. We use a lot of the same equipment, same type of servers. We got security just like VeriSign has for their .com and .net, and then all these other. There's a lot of small registries out there. I have just so many questions, because I could ask you about your relationship with certain registries, because that's interesting. You brought up the new GTLDs, but I'm going to ask a question, and then David, I know you have a follow-up, because it was something I wanted to get to, and we'll be jumping all over the place. But in the past, you defended a political newsletter in a domain name dispute. Since the UDRP is sort of a self-contained procedure, and it doesn't, adhere to any specific country laws, how do you make a free speech case in a domain dispute?
Okay, so a couple of things. One is that I represented a guy who started a political, like a Politico sort of thing, and it still exists, called Truth Out, truthout.org. There was another one too. I think it might have been .com. And he registered the domain name at the time because he was one of the co-founders. And they were in a very big fight because he left, and they were a nonprofit, and they still are. And they filed a lawsuit in LA Superior Court, no, San Diego Superior Court in California. And they also brought a domain name dispute. And what I was able to do is not actually defend free speech in that case. That was really about the fact that the issues that were brought up in the domain name dispute were similar to the issues, although not exactly alike, in the San Diego, California court case. And my argument was that it was not for a domain name panel to decide whether the domain name should be transferred or not because of the court case. So that's the first thing I wanted to just clarify. With respect to free speech, it's a really general term. Free speech is, to the Americans, free speech, we know what that means, but there are always, I'll say, guardrails against free speech. I mean, how far can you free speech, right? How does that wind up in a domain name dispute? Well, because there are a lot of there are people who register domain names and they have something to study, and that's a free speech right. With respect to domain name dispute law, there's really two schools of, or more actually. One is that the panel will look and see whether or not the use of the domain name is fair and non-commercial. In other words, you're not trying to sell anything on your website. You're really expressing how you feel about a certain thing. It could be, a disaster like an oil spill, and you hate the oil company, things like that, that will allow people to get out of it. That's when there's more scrutiny when you actually have the person's name in the .com. In most cases, there's, I would say, more lenience in the sucks sort of domain name dispute cases, like the, whatever, blank, that sucks, right? From the domain name right away that it's someone's expressing their opinion without going to the site. But the other school of thought really is, where are the people from, right? Where are the complainant and the respondent from? Does that make a difference? Panels have grappled with this for years. There is no uniform application of what constitutes free speech in UDRP decisions as of today. But the way that I just described the analysis is similar, whether or not the speech and what sort of domain name is a factor.
Yeah.
Some panelists believe that you should, if you're going to apply American principles and the respondent and the complainant aren't American, are they foreign? And there isn't as much of a, I'll say, if both parties are American, the chances are that if it's truly a free speech issue and it's not to divert internet traffic, I think panels will look at it and say, look, this person has the right. If they had to appeal it and take it to U.S. court, the U.S. court would figure that it's free speech, right? There's that school of thought. And then there's other panelists to the mutual jurisdiction that's decided when you file a domain name dispute as a complainant. And yeah, you have to show what sort of jurisdiction. It's either the location of the respondent or where the registrar is located. And certainly if there are foreign parties involved and they choose an American registrar where they're located, it could apply. And of course, the U.S. is not the only country that believes in free speech. You have the UK and the, in other parts of the EU and other countries. But, in terms of, there are other countries that don't particularly look at free speech. There have been decisions, domain name dispute decisions involving Australia, for example. But, that it all depends is really the answer. But yes, that's pretty much my answer.
Jeez, great stuff. I hope. I mean, I really mean that, because when the very first thing you said about that case, it was because of a court case, and when things are caught up in court for whatever reason, right? I don't think a UDRP panel should be making a decision on a domain name. And congratulations on becoming a panelist too. I hope when you do some cases, you come back, we can
Thanks.
review those. That's going to be pretty interesting. But so David,
I can't wait either.
yeah. David had a follow up. I know about some of the free speech, and it is a weird thing, because I think free speech is more narrow actually through a UDRP than through courts, at least here in the U.S. David, what follow up did you have?
Hi, Karen. So, hi. Do you consider the use of generic terms or trademarks that are registered elsewhere but not registered in the United States? For example, pretzels. Pretzels has been canceled as a trademark because it's determined to be a generic term for some sort of cracker. Would you, and if you were to come across a UDRP complaint about pretzels, how would you deal with that, being a U.S. lawyer and say the mutual jurisdiction is in the United States? What would come across your mind when you're dealing with that? And say there's a trademark for it in Canada or the UK.
What are the pretzels? What's the disputed domain name saying? Is it a criticism website?
No, it'll say they're selling pretzels and it's a pretzel website. Like, it's just another pretzel website.
It's a pretzel website. It's selling pretzels, and does the complainant claim that they have a trademark? Because you just said it got canceled.
In the United States, but they still might have trademarks in about a dozen other countries.
I see. Well, the first element in the UDRP is whether or not you have trademark rights, what we call standing under the law. Do you have the ability to show that you're the aggrieved party? And a trademark in a foreign country is a standing requirement. Sometimes you have to prove it through what we call common law rights, which is you use the mark for a time, never bother to register the trademark. And some countries don't even allow that, by the way. For registration purposes, you have to register the trademark. In the U.S., it's first to use. In other countries, sometimes it's first to register. So that's really a standing requirement. Remember, in a domain name dispute, you have to prove three things. You have to prove that, as a complainant, that you have trademark rights in the name that is contained in the disputed domain name. And secondly, you have to show that whoever registered the disputed domain name, the registrant, is not, it doesn't use it for what we call legitimate use, which is a very wide area of the law, which includes free speech, includes things like nominative fair use, which is you can't describe the thing any other way than what it is. So in your pretzel example, you might want to, somebody has a domain name, it says, our pretzels are delicious. I mean, there's no other way to identify them, right? And even if it's a trademark term, you wouldn't have comedy, you wouldn't have comedians telling jokes about TV shows or, movies or anything if we didn't have nominative fair use. So, it's like there's no other way to describe it. That's what that is. So that legitimate use, and also, do they have a bona fide real business? Sometimes in domain name disputes, the registrants have a business, they're actually operating it, and that's a factor to consider. And the third thing you have to prove is that the domain name was registered, registered and used in bad faith. So you have to show registered and used in bad faith. So, you might register a domain name, do nothing with it, although that's another area of contention. But, just say that, you're selling lettuce and someone else is selling pretzels, and you have a real business. That's a, domain name because you wanted to capitalize on the trademark. You didn't register because you were trying to target, traffic to your site to get clicks, and also advertising with competitive products of the person, the complainant who owns the trademark. So free speech is just one. I mean, that one element about having a trademark in another country is one thing to consider. Complainant has to prove all three.
Yeah.
Yeah,
They
thank
lose
you.
on one, they lose on all.
Yeah.
Yeah.
Yeah. Well,
Yeah,
David.
so you mentioned the nominal fair use and the legitimate interest. So that's great. Thank you.
Yeah.
Sure.
No, David, and it does. I've seen that in cases where in another country something's unique and they have a trademark. They bring it over and we're like, well, that's just means horse here, or and then it seemed like the panelists would they still have to go through, is there legitimate use? And Karen said something, Jeff, I wanted you to comment on, and that is about having a real business. Because yeah, you might have something. It seems to me like the panelist always ends up looking over to the respondent. If there's no response, well, you're really in trouble. But looks over to the respondent and wants to know, just you got something real going on there. How important it to you, Jeff, as a panelist, to know um, there's a real business behind it? Because a lot of us, the business hasn't been set up yet. So how important is that?
Yeah, I mean, depending on where the domain is in the life cycle, right? If you've only registered it a month, 2 months ago, 3 months before the case was filed, panelists aren't going to necessarily that there's this huge business that you can see on the website, but they'll look for what's called demonstrable preparations for that business, and so they'll want proof. I mean, look, it's pretty easy to say something in a response that you intend to use it for a particular business or that you are using it for a particular business, but the UDRP is about providing evidence for your statements. Now, granted, overall, it's the complainant's burden to prove that you've registered and used the domain name in bad faith. But if you're going to say that you're using it for legitimate purposes, or as Karen said, for a bona fide business purpose, then it's your job to actually demonstrate that. It's not, once the complainant shows that, the domain name itself is not, um, you're not known or commonly known by that domain name, nor is there any obvious ties between you and that domain name. If you're going to make the argument you have legitimate rights because of this so-called business, then you do need to provide evidence of that. And so it is very important that if you say you have a business, to actually demonstrate that, because by the time the burden shifts to the respondent, the respondent does need to put up its evidence.
Okay, that gets me to domain name investing as a business. So, because all of us here are like, yeah, listen, I don't have anything on there. I'm a domain name investor. So, when you now Karen's a panelist as well. When you, what makes you what makes someone qualified as a domain name investor where that's a legitimate business? So flat out, as soon as that's a legitimate business, you can't prove the number two limb, prong, whatever you call it. I'm not the lawyer, Karen. You can see that. So I mean, if someone says they are, I'm a domain investor, what proof do you need from them? First, Jeff, and then Karen. Think about it. What proof do you need from them to show that they're a legitimate domain investor, legitimate business?
Well, I mean, for starters, the most obvious thing is, okay, well, you say you're a domainer. What does your portfolio look like? What were your sales like? Something that would give credibility behind the notion that you are a domainer. Now, just because you say you're a domain investor, and even if you provide proof of that doesn't automatically give you a right, um, or doesn't automatically get you out of whether the name was registered used in bad faith. For example, you could be a domain investor, but you purchased a name that is very well known that you really should have known was a trademark, and you're selling it at a price that's really only the trademark owner could afford. Those are the types of factors that could be used against you, and certainly pay-per-click ads. If you're making money off of pay-per-click ads, and those ads are either competitive with the complainant or pointing to the complainant, then that is also something that would not be seen in your favor. So you do, as I think I said, a bunch of times on this. If you want to qualify and argue that you are a domain investor, that is a legitimate business. But with that legitimate business does come some responsibilities, and those responsibilities may include, some diligence on checking to see whether the names in your portfolio have marks against them, right? You can't have the benefit of saying I'm a legitimate business domain investing without absorbing some burden of diligence. Now, I'm not have to search every trademark database in the world or do that kind of diligence, but if it's pretty clear that yes, there are marks in the U.S. and you know every other version of the domain other than the one that they're seeking is owned by the complainant, there are certain things that a domain investor as a legitimate business does have to do to maintain its credibility as a legitimate business.
Yeah, you're hold on because Karen, I'm getting ready to go to you. Karen, this is wonderful to be able to ask you questions like this, and we'll get on. But that was our next question about the duties of a domain investor. But first, Karen, so a domain investor, and then not to you is I mean, Jeff brought it up. You can't just be a domain investor and think you can get away with everything. But a legitimate domain investor, yeah, I guess. Well, I guess it's like now he's confusing me a little bit because he's making me think it's like common law. Sure, you can use that to show standing, but you better have your stuff to back it up. So he's sort of saying that with a domain investor. You want to say you're a domain investor, this better be fall in line with that. But I'm sorry, go ahead and how would you answer that?
Here's the thing. I totally agree with Jeff's assessment. I think that part of it of the ways that might help you as a domain investor if you're trying to show you have a legitimate business. Of course, you have to do the due diligence. You have to make sure, but that's the cost of being a domainer. If you, depending on how many domain names you own, if you own 10,000 names, it's a lot to keep up with, right? But like if you're in a drop catch situation or you're in an auction, before you bid, check it out. There are things that I see at domain auctions that I go, but also, if you do, you better be really ready for that. The other thing is, I think that, there are domainers out there that have a niche within their portfolios. The most recent domain dispute involving Babista, Babista, that was where, the guy obviously loved domain names that ended in the letters ISTA. Like sometimes you're going to get caught up if you're good at what you do or you have good domain names. There's always somebody who's going to be looking to sue you. I'm sorry to break this, but that is if you're lucky enough to have really good domain names, and it happens to people who are sophisticated holders. I'm not saying everybody's like that. Obviously don't register trademark domain names. Like that's a dove, right? Don't do that, or typographical. But like if you have a good domain name you're planning to spend a lot of money on, you need to make sure that it doesn't infringe anyone's trademark. You can only look so far. I did a workshop at the IC meeting in Vegas on ways of like figuring out, looking at the U.S. Trademark Office database, looking at the WIPO Global Brand Database, and looking for exact matches of names before, or comparing your portfolio or before you buy a domain name. It's never 100% going to keep you from learning everything because of, I'd love to take your money and do trademark searches, full trademark searches for you. But if you're looking at, 10 domain names plus, it gets cost prohibitive. So you just have to be very careful about what you're registering. And you have to realize there are risks involved.
Yeah.
And some people in the domain name industry can take it, and some just say I can't take it.
Yeah.
So
yeah, there's Karen. You touched on so much because there's a lot of guys, like you say, you're lucky if you have somebody sending you a notice because you probably got something valuable. They think it's theirs or they want it to be theirs, and the issue with a lot of some of the same people we know, when they've had names for 25 years, that's one thing when someone comes after you. But when you've just picked up a name for 150,000, and then basically you have a lot more
that's
in
a
it,
shame.
yeah, and then they're thinking, hey, and then people start using that acquisition date as your date after their trademark. This name's old, but you bought it for a different reason, and you do have rights, of course, but it's just how they come after you. So I like, and especially you made that comment about a comprehensive trademark search. Yeah, it's more than the little two places you mentioned. It's really detailed, and that's why I see these last few years lawyers were putting on their websites comprehensive, and they weren't doing comprehensive searches. They were doing, really shallow searches.
Exact
Yeah.
searches.
Yeah.
I know. Well, the thing is, you could get really into it, try and find confusingly similar. It's very complicated stuff. It's done by AI through a third-party company I use, and then I analyze the results. But, check and see other extents too. Like, you could do something as basic as that to see who's doing what in other extensions, particularly .com, .net,
Yeah.
and the more popular like .ai or .tv, to make sure that there isn't something there. It's not a foolproof way to do it, but look at how to use the U.S. Trademark Office database is getting to be challenging, but it's doable, and WIPO, and see what's there.
Yeah. Thanks,
Before you
Karen.
buy.
I have so many questions, but I want my co-host to ask some. But I have good ones, and one about a trademark, basically cancellation that you did. But first, I have a guest on stage, Arif, and he has a question for you. And we always like a question from the audience. He's a domain investor. Arif, please.
Hi, Arif.
Unfortunately, we can't
hon.
hear you. Yeah. So at least we hear the same thing, Karen. Yeah, Arif, I don't know. Maybe
How
go
we
ahead
doing?
and come back up. But no audio.
Okay.
He's pretty slick,
All right.
so he'll know how to come back. Well, so tell us, this was a question I had for you. But basically, I knew David would find this interesting. About the time you had to successfully cancel a federal trademark, and I just listed it out like that so the average person could think, what does that mean? So there's a trademark, and we hear about that sometimes they get canceled. But what happened in your case?
Well, it was so I don't. It wasn't canceled. The trademarks weren't canceled. It's part of sometimes a litigation strategy, which I'll be speaking about hopefully in London at the Domain Summit coming up August 2021, August 20th, 21 to 21st in London. I hope you can make it.
Yeah.
And it's a defensive move, I've done, and they were involving the two domain names actually were involved in two different cases. One, well, actually, there's more than that. Sorry, I've done it. We didn't go to cancel their mark; we opposed it, I think. But in these particular instances, owned domain names, prime domain names, right? One was as a result of a UDRP. Let me think. So one of them was through a federal lawsuit. And what we did as a defensive move was we went and tried to cancel their federal trademark to make them come to the table and settle, which we did. Okay. And then the other one was, right, that was a crazy case. That was a case involving the domain name primp.com. The plaintiff was a clothing company, and it was very convoluted. They had a temporary restraining order that was filed under seal, meaning that nobody knew about it. There were other defendants, and of course they wanted a domain name for my client and made up a convoluted story about how my client was involved. Totally absurd. But we didn't get their mark canceled, but what we were able to do is to get the judge to fine the plaintiff's attorney because she had some problems and was really out of control. And I think the judge ordered something like $15,000, $20,000 she had to pay to my client. And she said she didn't have the money, so she had to pay through the court in installments. But we didn't cancel their trademark. They were just, they really didn't know what they were doing. I don't know if it was canceled. It was a long time ago. The other one was that one was because they were threatening sue through a cease and desist letter. And we settled that as well.
Yeah, I'd like
Sorry to say, I've never successfully canceled a trademark, but I've been very successful for my clients in using it as a shield.
Well,
And I've opposed trademark applications. That's before you get a trademark registration, when they're pending in the trademark office. And I've also brought what we call declaratory judgment cases in the federal court to stop someone from trying. I have one right now, actually. It has nothing to do with domain names. It has to do with cannabis conference, but we'll get to that.
Yeah.
Yeah.
Well,
So go ahead.
Karen, I wanted to say, and that's before you even said cannabis, was, yeah, I wish I would have met you before I met some of these other lawyers. Anyway, I know about, and I'm just kidding. Fortunately, I didn't hire any of these other guys anyway. They're, at a certain distance. But the reason I say that is because what you're doing is so important to a partner of mine, I'll say, that you have these premium names. People come in and start doing stuff on some of these names that are, you consider generic, just a wide variety, but believe it, they're all premium. And then we have to tell people, you can't just do that. And now and plus you can affect the value of these assets over here. And so it really, the defensive move, you got to be offensive and defensive. But I love it. I love that you were touching on that. And then Jeff knows.
Well,
Go ahead.
but the problem with some of this is that, it's, I would say that, to get into a situation, it costs money. And if, a client is not, as wealthy, I'll say, as other clients, that's a consideration, but it's not cheap to get to these points, to fight that. Funny story. I represented this, I still represent them. They're a company that runs pub crawls all over the country. And they owned a ton of SantaCon domain names. And if you're not familiar with SantaCon, are you familiar with SantaCon, Todd?
SantaCon? No, is it no?
SantaCon.
SantaCon.
So SantaCon started in San Francisco. Well, started in Denmark. It's a long story, but basically, people run around in Santa outfits around Christmas time. They have them all over the world, and they started very, I'll say, innocent, because I was at the first two in San Francisco, and they became what is known as a drunk fest, where, really gotten to the point of disgusting, especially in New York and San Francisco. You don't want to see Santa, upping his beer on the sidewalk in front of a child, so it's gotten really out of control. But they run pub crawls. They do Ugly Sweater. They do St. Patty's Day. They do all that. And they do SantaCon. So they make deals with bars, and they say, we'll include you in our pub crawl, and you get to take all the money, from the bar, and we sell tickets. And that's what they do. And there was a SantaCon, and there were SantaCons all over the world that obtained a federal trademark for SantaCon in the U.S. for nonprofit, arts participation sort of things. And they brought a domain name dispute against all these domain names. And it was never published, because it was basically, we wrote and said, this is not here, because we went to federal court and sued a federal court for a judgment from the court that we weren't infringing. That case, oddly enough, did settle right before COVID, like around when I saw Jeff, and that was fortunate. But yeah, we opposed their trademark. We canceled their trademark. No, we didn't go after their trademark. Maybe we did. I don't know. Time flies. Sometimes you forget. Yeah. But yeah, that was a good outcome for the client. Can't really talk about it. Yeah. So there you go.
Jeff, what question you might have? I have a few more about being a broker, but go ahead, Jeff. You hit it.
Yeah, I was going to ask. So just recently applied for and became a panelist for the forum, and so maybe you could just tell us. I don't know if you've been given any cases yet. Kind of early, but maybe you could tell us why and what you're looking forward to.
Oh, great question. First of all, no, I'm waiting for them to come to me to do it. Just take a look at the case. I really like the fact that I think it's something at my maturity level as a lawyer. I've been doing this for 23 years. that I think that I can bring balance to domain name disputes. And a lot of people would think, oh, well, you understand domain investors, but yeah, sure I do. But I'll still be neutral. And I like it. I think it's something I can do as I get older. And I feel like it's a way of enriching myself intellectually.
Yeah.
Yeah, I think that's great. Just for everyone here, I definitely endorsed Karen.
He
To
did.
be,
Thank you, Jeff. And Steve Levy, who was on the call, but I think left. Yeah, he did.
He's
Okay. Yes.
yeah, yeah. So because I think you'll make an excellent panelist. I would just as some advice, keep on them, keep asking. To get that first case, because they have a lot of panelists, and sometimes they just sending a reminder often helps.
I will certainly take that advice. Thank you.
Yeah, and Steve, I see Steve still here. Steve wrote this such a good um, article on, and I know the title because I like it. How to lose a UDRP, and it's for the brand side, and it's such good points that because I've read in the middle of reading Jerry's book, which is really not as long as I thought. But anyway, Jerry's book is good to go just right to whatever chapter you need. It's just filled with everything. But what Steve put together, really interesting. You guys can all get this stuff at internetcommerce.org. I mean, there's a basically just click. You'll find it, but click under UDRP stuff. But Karen, you were, when you said I can be neutral. Well, of course, you say you're a domain lawyer. You could be neutral. Well, early on, you were pretty tough on domain owners. I mean, more of a brand person. So I can see. You certainly can be a. I'm sure you'll be fine. I know there was something about.
I'm sorry. I want to interject and say that, yes, I have represented brand owners and UDRPs, and I've represented domain investors and other people, domain investors and UDRPs. So that's especially why I think I can be neutral, because I can see both sides.
Yeah.
But I'm sorry, Tad. I didn't mean to interrupt you.
Oh no, I might have a question. And then Arif, I want to bring him in. He was so nice. He said in case his audio wasn't working, he didn't want to mess with the flow of the show. But we're going to be around for about 5 more minutes. We'll just stop right after the hour. But it was really about, I wanted to ask you, because you've done it. What are the benefits of a domain investor using an attorney as their broker or their in between in a domain sale?
Yeah, I've done it. I'm able, most of the time it's under NDA and it's dated, but I did broker Occupy.com during the Occupy moment. But yeah, I mean, it's there. The benefits are that you get me all package, including your purchase and sale agreement, negotiating, all of that. So, brokers have their standard agreements that aren't necessarily going to protect you as much. Other people, depends on the domain investor, may not want to accept broker's purchase and sale agreement. And so that's important. I used to do escrow very early, and I decided not to do it anymore. And the reality is it's kind of a hassle.
Yeah.
Because if they're running money through your firm's trust account, then you get a percentage. And if there's a dispute between the parties, you then have to go to court and to get paid regardless of the sale. And so it's just not part of my everyday practice. And escrow.com, they don't pay me, but I think they're very reputable and their rates are really competitive. There are others out there, but that's generally who I use with clients.
Yeah, and I don't like to say it out loud, but I do. And that is, you know what, escrow, that's like personalized credit card transactions, meaning the fees are low. The gentleman Matt Berry was on an ICA call yesterday, fantastic call. Was it yesterday? I can't remember, but I think it was yesterday evening. But it was fantastic. He's a businessman, and he is like, our numbers are public anyway, so I knew him before he shared a lot of them. But you're right. So the escrow part of it is definitely something people think, so the attorney can do this too. That's not the important part. Like you said too about the agreement. You're going to have agreements with brokers, attorneys. I feel anyway, I prefer that myself. I would say to go through an attorney if it's a big transaction, because I like their terms usually better than some broker. But anyway, and usually the agreements are written better. Arif's on stage. Arif, let's see if your audio is working. Nice to have you.
Hey there, check one, check two. Can you hear me?
Sounding pretty
Yeah.
good.
Hi, Aaron.
Great. Hi guys. Yeah, I wanted to just push back a bit on the whole responsibility of domain investors. Yeah, because for me, like back when I was buying maybe 10 domains a day, whatever it was, and searching maybe 50, and obviously like not targeting anything. If you guys know, I've been pretty vocal when it comes to new domainers and trademarks, and to avoid obvious ones. And
Right.
I don't search either to search and target, right? Like to me, I totally believe, and I tell people, yeah, if you have a domain name that you've bought and you've priced it at a price point that only makes sense for one company who owns an existing mark, like that's just cyber squatting, right? So I'm very vocal on that kind of stuff. But at the same time, like I typically buy like two-word.coms, and there probably are companies that match my domain names, but I never look out to target them. I on brand value. I have a portfolio of about 3,500 domains, and I don't have, like again, I don't feel like it should be my responsibility for every single domain I buy to go and actively pursue it. That said, like if I'm on Google and I see something, I shouldn't be actively targeting either, but I don't, so I don't like that requirement to really proactively look at the databases or any other form of listing to really search for every single one of my domains. But again, I also feel like I would be responsible if it was a well-known mark, right? Like if it's a well-known mark in my country, or if it's a global brand or whatever it is, I do feel that the leeway there should be a little bit less. But at the same time, like actually to look out, I don't know about that.
I think that I see your point. I appreciate your comment. And, there have been UDRP decisions where the panelists have said, um, this is obviously somebody who's a sophisticated domain investor, and we will hold them to a higher standard because they're professionals and not just sue
Yeah.
registered a domain name unwittingly. So that's the reason I say it out of love and protection
Oh yeah,
to
I get it.
investors. But on the other hand, there are trademark trolls. We all know this, and unfortunately they exist. And I wrote about reverse domain hijacking in like 2009 in a Domain Name Wire article. And I find that the reverse domain hijacking, as the decisions have gone up, but the problem is that the poor domain investor, and they're not necessarily poor, but like to have to be put in the position where like some of the UDR complaints or decisions that have been reviewed recently, where the person claims or the company claims they have a trademark that doesn't even match the domain name, and somebody has to go, domain investor has to go and hire a lawyer or try to defend themselves or not even respond for that matter. And I think that that is the extreme of the other end of the spectrum.
Yeah, and to be honest, we're probably almost saying the same thing. Like you're saying higher standard, but probably the domains that I have, you would, as a panelist, would probably say, oh yeah, that's not really a well-known brand, and I get the genericness of it, and he's pricing it at like $4,000. That's not really what you're looking for exactly, right? Whereas some of the ones that like have specific, better-known brands and hyphenated stuff and deliberate sort of stuff that you can tell are deliberately sort of trying to get the money trademark thing. And that's the good thing, is that there's panelists and judges that can kind of get the gray zones, read the context, read between the lines. But yeah, so I've never had any issues with any
Well,
marks.
I'm
But
glad.
I don't know.
Yeah.
Yeah,
That's
I mean, if I would just say, and I think Karen would agree, there comes a point where what you're going to spend, there must be some amount of money that you're like, I really want that name, but it's such a high amount. I better take a look at Google and just take a look, because if I'm going to spend this amount of money on a name, I should know what my risks are and what's out there. Um, I
Yeah,
would think, yeah.
yeah, that's a factor too, because I'm very proud to be the world's cheapest domainer. Like most of my acquisitions are closeouts, especially back in the days when GoDaddy closeouts were between $5 and $11, right? So for me, I blitz stuff, I buy stuff in batches, and it just didn't make any sense to waste so much time and energy going through trademark searches, because then the math of my portfolio would no longer make sense if I had to calculate for all the extra time, right? So.
Right. And I think that that's different. There's other domain investors that are willing to spend, 6 figures or 7 figures on a name. It's pretty reasonable for them to do some diligence on what they're going to get if you're going to spend that kind of money.
Yeah, and I totally agree with that, right? That's what I'm saying. Like, context matters, but it's like, again, for me, when I go in a buying blitz, I don't feel the need to, look for trademarks unless, again, it looks like something obvious or something very unique or something. There are cases where, yeah, just looking at a domain name, it should be like, yeah, that triggers a little bit. Maybe I should Google that and whatever it is, and I do that from time to time, right? And there are times when I do find something, but it's certainly not something I do for every one of my purchases. But again, same thing. Like, if I had a UDRP, most of my stuff I would feel very confident based on my knowledge, thankfully learned by all people like yourselves. That, yeah, no, this case, it's more of a brand, and it could be open vessel. There could be other uses to it, or the mark using it is a very specific location, or there's a lot of ways you could get a domain name that you're free and clear. But again, for me also, I never go looking for the mark after buying a domain and then reprice it based on the mark. To me, I also think would be wrong. Like, people all the time, they go, "Oh, I got this domain. Oh, but this company uses it, and they're asking me whatever it is." I go, "Yeah, you should price it at what you think the second most popular company who it is, never the first, right? Because then you're embarking on their brand, on their good they've built over the years, and that's wrong, right? That's when you become a cyber squatter. But anyhow,
Well, wait, hold on. We normally, Karen, it's normally 60 minutes, and for a guest, I'm like, I wanted her to be able to get out of here fast, maximum 75. So we're only going to go like 8 more minutes. But I have that cannabis question because there's Larry's in the audience, a good friend of mine, and a few others that I know would like to just hear your connection to that space. And I have another question after that. But so thanks for keep sticking around. I'm not much longer. But so tell me, I read that article in Honeysuckle magazine where you were the featured subject. You were offering suggestions on, for those interested in starting a cannabis brand in New York. More general, what's your connection to the weed business was my main question.
Well, let's see. All right. So I'm an original burner, as in Burning Man. You know what Burning Man is, Todd?
I'm a burner the other type. Matter of fact, I'm going to go on mute. But
Okay.
anyway, yeah, no,
So
I got you.
you know what Burning Man is? You didn't know the other thing, but
Yeah.
SantaCon. But yeah, it's because Burning Man was kind of grown out of SantaCon. The people who, well, it's hard to explain, but anyway, it's kind of connected.
Okay.
So it was a long time ago. I went to the first two burns. I dated Larry Harvey, who is not with us anymore. He founded one of the founders of Burning Man. And obviously, they smoke weed at Burning Man. It was California, and hey, that was it. I wasn't a lawyer yet, right? Years later, when I became a lawyer, I ran the Google ads, like I talked about. And a guy called me up, and he was from New York, and he was a lawyer, and he was working with some friends of his in martial arts, in Filipino martial arts, and he needed me to represent his clients in a litigation in New York federal court involving lovely brother versus brother over their names. Case settled. But anyway, we got to become friends, and we were talking, and somehow it came up that I was an original burner, and then he was like, "You're not worthy," like bowing to me, which I kind of found amusing. But later on, he moved on. He went. He was working as general counsel. He's a general counsel type. He was working as general counsel for he was in New York still. A company based out of California called the Arcview Group. They've since moved to New York, but what they were basically was like the Shark Tank
Yeah.
for the cannabis industry. So there would be seasoned investors like from New York and other areas of the country that would judge startup cannabis companies in California, because it was medical at the time. So that was like 2013 or something. And of course, I didn't know who they were. And so my friend and colleague, they needed trademark work. and he brought them to me, and I did some trademark work, and they really liked it a lot. And then I started going to their conferences and became a member and all that. And then my friend left to go to another company, and they kept me, and I was outside IP counsel to them for years. They were then acquired by another company, and people made an exit. And when that happens, sometimes the new people come in want to use other law firms. So, but I was with them for about 7 years, as an outside lawyer, and through that space met people in the cannabis industry, and started working doing white label licensing and trademark work, although you can't get trademarks, federal trademarks for cannabis, but other things like a conference can, because it's not necessarily, you're not growing it or selling it or anything. But, in other instances, a brand wants to come in and they want to have a cannabis brand, but they're not in the cannabis business. So they want to have what we call co-packing or white label agreements with people who manufacture cannabis. They process it. They're the ones that they don't grow it. Cultivators sell to them, and then they turn it into, like a cigarette, or they'll put it through a process and make it so that you can use a tincture or a gummy and things like that. And so I've been for the last 2 years doing those sorts of deals, where mainly I'm representing the brand that comes in from out of state, and not in New York. New York has special laws, and it's still very early here, but California companies doing deals in California with California lawyers, naturally, because I'm not admitted there, but other deals where I am, and it's medical there. And in Massachusetts, I was working with firms of counsel doing work with them. So, it's an interesting field. I've spoken at many of those conferences over the years, and it's another niche.
Yeah.
Asian publications to the internet to cannabis, and sometimes there's a crossover between cannabis and the internet. I don't want to belabor this, but I did have a domain name dispute. It was not a formal one, over domain names, and they were for what we call dispensaries, the retail legal sales. So that was kind of fun.
Well, Karen, I'm like you. You don't know a lot of my background, so we cross over. I can't believe with ArcView. Yeah, back then that was Troy Dayton started that, right? Is that who?
Yes,
Okay,
yes,
so
Troy Dayton, and
and because
Harbor.
I would go right, I would go everybody, bunch of real smart
D'Angelo,
guys. Yeah,
D'Angelo,
yeah,
Steve
Steve
D'Angelo.
D'Angelo, and Steve had the
Yeah,
big spot up there. We went through very similar things. Steve and I did,
you
meaning
did.
yeah, just
You went.
he
Oh,
from
fun.
say for what he did in Northern California, what I was doing in Southern California, meaning we've had experiences with the federal government. But the point is about the good and the bad. Hearing well, no, I remember all that, and I remember when they would I thought it was fantastic. Of course, some of us in the business were like, okay, so you know. The Shark Tank type of thing. I went to a few early conventions, but those of us really doing real business, we're not really going to a lot of the conventions, and pretty much everybody's autonomous. Everybody's got their own. Still out here, it's messed up. I mean, it's sort of messed up with
Well,
the
this
brands.
was
Yeah,
earlier.
yeah, yeah.
Yeah, this was years ago.
But
Now we're talking.
yeah, yeah. Well, we definitely. So before we so I saw two official websites for you because I was, they both are websites active and they got the right pop up at the right time, meaning so people can contact you and do business with you if they need to, if they need your representation. So I saw KarenBernsteinLaw.com and BernsteinIP.com. Which do you prefer?
Yeah, it's BernsteinIP.com. KarenBernsteinLaw.com was the first domain name that I operated on, and I've been Bernstein IP probably for the last 8 years,
Well,
something like that. But whenever people are looking for me, sometimes it's up through SEO, and so I keep it.
yeah, yeah. That's why to me I thought Karen's just being smart of knowing somebody searches this good. Why would I take it down ever? And then, like I said, no, I thought
Correct.
like funneling any leads, but it's been a pleasure having you here. I know I'm gonna talk with you. I just want to let everybody else know, here's how to get a hold of Karen. If you can certainly use her vast background. We didn't even get a touch on stuff. When you have your first case, I'll tell you a secret. Is Zach still here? Zach, he's pretty smart. Okay, so what he'll do is,
I think he left.
yeah, what he'll do is, he doesn't like to comment on any cases that he's involved with. So he made that rule, and it's smart. Okay, but we don't like it because Jeff talks about stuff what you can talk about. You know what I mean? And every lawyer has NDAs and all sorts of stuff, or really their own limits on what they know they want to say. But anyway, when you have your first case, we're going to talk about it. I mean, I can tell you next week we're talking about that Young.com case. So two things.
Oh boy.
When you have
Yeah.
when you have your first case, certainly I'm going to reach out and invite you back here. And then, of course, we do this every Tuesday. So sometime you're always going to be, you're free to just come in and say, hey, I want to comment on that case. We put our outline up, now you know, at dnlshow.com. Well, usually instead of all this stuff of you today, usually we just have like a few news articles and 4 or 5 UDRP cases that we're going to review, recent cases. So if you ever see one on there yourself and think, hey, I want to come in and tell these guys, what's correct. But the reason I say it, I did just watch.
Do you have an email list? Do you have an email list?
I don't here. I do it just on Spaces because we've made a mistake from the start. It's been over 3 years ago, and we let me approve it. It's been over 3, and no, I've never got an email list from these people. I think I'm just going to ask. Well, they have to just come here to see it. Okay, so I think Larry came up. He wanted to say one last thing. It seems to me like Mr. Larry Love. Hey, Larry, nice to have you.
Hi. Thanks for the room today, gentlemen, and Karen. Thank you very much. I have such a simple question for you. Since
Sure.
I say that facetiously, sarcastically maybe. If cannabis goes to Schedule 3, what does it do to the current medical cannabis industry?
Well, that is the question for everybody to decide, right? I frankly don't think it's going to go to Schedule 3, but if it does, it is a question. How is that going to work with the FDA? It's a really complicated question, but I don't know whether it's really going to happen. The politics, the president, all of that, there's been some demands from Congress about looking at the details, what this would entail, and nobody seems to know.
Yep.
So I'm sorry I don't have much more to say about it.
Yeah, you did exactly what I thought. That's my opinion also. It's a quandary right now. It's who knows if it'll change at all right now. There are a lot of people in the medical industry that don't want it to change. So thank you very much for being here today. Appreciate it.
No worries. Pleasure.